Start. In heavy engineering case under bracket supra, industrial dispute was referred under section 10 of the Industrial Disputes Act by the state government of Bihar to the Industrial Tribunal for its adjudication. Stop. The competency of the state government was questioned by the Mazdoor Union, contending that the appropriate government to refer the dispute was the central government. Stop. The High Court negated the contention and had upheld the validity of the reference. Stop. On appeal, a bench of two judges had held that the words under authority of means pursuant to the authority of the central government. Stop. Placing reliance on common law interpretation, the bench was of the opinion that the company derived its powers and functions from its memorandum and articles of association. Stop. Though the entire share capital was contributed by the central government and all the shares were held by the president and officers of the central government were in charge of the management, it did not make any difference. Stop. The company and the shareholders are distinct entities. Stop. The fact that the President of India and certain officers hold all its shares did not make the company an agent either of the President or of the central government. Stop. The power to decide how the company should function, the power to appoint directors, and the power to determine the wages and salaries payable by the company to its employees were all derived from the memorandum of company and articles of association of the company and not by the reason the company being the agent of the conclusion on the basis of concession and on private law of principal and agent, and as regards a company registered under the Companies Act on the basis of the power of internal management. Stop. In Hindustan Aeronautics Limited case under bracket supra, learned judges merely followed the ratio of heavy engineering case. Stop. It further concluded that the enumeration of certain statutory corporations in the definition would indicate that those enumerated corporations would come within the definition of the appropriate government without any further discussion. Stop. In Il Majdoor Union case, a bench of three judges, while interpreting section 32 subsection 4 of the Payment of Bonus Act, considered the purpose of the expression under the authority of any department of the central government for purpose of payment of bonus. Stop. The meaning and scope of the expression industry carried on by or under the authority of any department of the central government was examined, and it was held that the industrial undertaking retains its identity, personality, and status unchanged, though in its management the central government exercised the power to give a direction under section 16 and the management is subjected to regulatory control. Stop. It is seen that the above decision was reached in the context in which the payment of bonus was to be determined. Stop.